A defendant admits to failed drug tests, curfew violations, and multiple probation breaches. The judge has every reason to send him straight to prison. But what happens next shocks the entire courtroom when Judge Raquel West offers one final chance and makes it clear there will never be another. Stay until the end, because this warning could change a man's life forever.
Okay, I guess just obviously by what I'm looking at, that seems, am I looking at the right thing? Dakota Chapman? The first violation is that he committed the offense of murder?
That has been abandoned.
That was not.
Yeah, definitely.
Okay,
I'm sorry.
thank
Maybe
you.
we should have started with that.
We're just gonna go to safety and,
No,
okay.
that
So,
was done in December. Here's.
let's do this. I'd like to go ahead and go through the motions, get pleas of true or not true to the remaining counts. And then obviously if you guys have an agreement, we'll look at that, but I think I want to go through and have those pleas on here.
And that came at the recommendation of his supervisor, who
Okay.
I'm sure has much more information for the court as well.
That's good. Thank you. If you want to print this section, I'll just do the first one on here. All right. Will he waive the formal reading of the motion in each case? Mr. Chapman, in clause number 23, DCCR 1077, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation May 6th of 2024 for the offense of evading arrest or detention with the use of a vehicle, a third-degree felony, and that was a 5-year deferred probation. Is that correct?
Yes, ma'am.
And then in clause number 23, DCCR 1078, I also have a motion to revoke your unadjudicated probation. This shows that you were placed on probation May 6th of 2024 for the offense of accident involving injury, a state jail felony, and that was a 5-year deferred probation. Is that also correct?
Yes, ma'am.
And so the state is going to abandon each case count 1, correct?
Correct, Judge, based on the comments of the grand jury.
So, Mr. Chapman, in each case, the motions allege you violated your probation. Count 2 in each case alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true? Count 3 in each case alleges that you provided a urine sample March 12th of 2025 that tested positive for cocaine. Is that true or not true? Count 4 alleges that you provided a sample September 3rd of 2025 that tested positive for methamphetamines and amphetamines. Is that true?
True.
Count 5 in each case alleges that you admitted to your probation officer to using the illegal drug ecstasy December 3rd of 2025. Is that true or not true? I'm sorry. Count 6 alleges in each case that you were at a location other than your residence at approximately 1:53 a.m. December 21st of 2025. And is that true or not true?
True.
Count 7 in each case alleges that you failed to successfully complete the defensive driving course as ordered. Is that true or not true?
True.
Count 8 in each case alleges that you were behind in your court assessed fees. And is that true or not true?
True.
Did you enter your pleas of true in each case to counts 2 through 8 freely and voluntarily? And did you plead true to those counts because they're actually true? So it's my understanding, Mr. Chapman, that the recommendation is that I continue your probation and order you to enter and successfully complete the special needs SAFEP. Is that your understanding?
Yes.
Is there any reason to get any type of pre-sentence report or update?
Only at the court's discretion, Judge. The officer, Ms. Valier, has already prepared for the court the continuation and modification of that special condition that the court would like that to be signed off on today. Otherwise, I'm sure she'd be happy to do a quick update.
If it's her recommendation, we'll just go ahead and go forward.
I think that was, I'm sorry to interrupt, I think that was done prior to count 1 that we see, which obviously caught everyone's attention and just took that immediately off the table. But
Right.
since that was no build, I think that's when she finds herself back in the same position.
So, Mr. Chapman, you're getting your second chance today.
Yes, ma'am.
There's not going to be a third. Okay. You need to take advantage of this. I don't know what happened. The night of December 21st to 25, obviously it was no build as far as the offense, but you were clearly somewhere you shouldn't have been doing some things you shouldn't have been doing, right?
Yes.
If you had been home during curfew, you never would have been charged with anything. There wouldn't have been any issue of whether or not you did anything, right?
Yes, ma'am.
So I want to make sure you understand if I go along with this and send you to SAFEP, you're going to get some tools so that you can hopefully stop using drugs, do the right thing, live your life like the rest of us and not end up in prison. Do you understand all that?
Yes, ma'am.
All right. So at this time in each of your cases,
I don't know how the court would feel about a extension, Judge, based on the age.
yeah. So at least in the evading,
Okay.
I'm going to do that. I'm also we're going to talk a little about the jail incident reports as well in just a
Yes,
minute.
ma'am.
So I'm going to find in each of your cases that you entered your pleas of true to counts 2 through 8 freely and voluntarily. Find those counts true, find sufficient evidence in each of your cases to revoke your probation, but I'm going to go along with this agreement today, and I'm going to continue your probation in each of your cases. In clause number 23 DCCR 1077, I am going to extend your probation by 2 years, and I'm going to order in each of your cases that you enter and successfully complete SAFEP. That obviously means going through the program in custody, but it means getting through the aftercare and everything else successfully. If you do all of that, then you're still on these deferred probations. You still don't have felony convictions on your record. This is, again, the opportunity of your lifetime right now for you to make the changes and do the right thing. If you don't, and you come back in here, then you are going to end up with 2 felony convictions, and you're going to end up going to TDC for up to 10 years in one case and state jail prison for up to 2 in that case. Do you understand?
Yes, ma'am.
Let me explain something else. I am also now making it a condition of your probation that you treat the staff and the correctional officers at our jail and at SAFEP and wherever you are with respect, and you follow all of the rules when you're incarcerated. That means if I get another incident report before you get to state jail, before you get to SAFEP, it's already a violation of your probation. They're going to let me know, and you're never even going to make it to SAFEP. You're going to be right back in here and looking at going to prison. Do you understand?
Yes, ma'am.
So the way you're talking to them at our jail, you cannot keep doing that. You cannot keep arguing. You can't keep fighting. You can't keep saying, F that, I don't care, things like that. Okay. And you're looking at me like you're confused that maybe you didn't do these things, but this is what I have. Every time you act up, every time you tell someone, if you're going to send me out, just do it, F that, or whatever it is, that's disrespectful.
Yes, ma'am.
All right. They're just trying to go there and do their job every day. Hopefully someday that's what you want to do. Get out of jail, go to work, and not have somebody treating you like this when you're at your job. Right?
Yes, ma'am.
All right. So you'll sign some paperwork today for SAFEP, and I think that's it as far as adding the condition. So add 2 years in the one case and the condition with regard to being successful and not being disrespectful.
Yes,
Okay.
ma'am.
All right. Good luck to you. You can go back with the bailiff. Good morning. Are you Tamara Henry? And Mr. Parker, will your client waive the formal reading of the motions in each case?
Yes, and they're both the same type charge and the same violations, Judge.
Thank you. Ms. Henry, in clause number 14-19449, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 4th of 2016 for the offense of aggravated robbery, a first-degree felony, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
And then in clause number 14-19-624, I also have a motion to revoke your unadjudicated probation. It shows you were placed on probation January 4th of 2016 for aggravated robbery also, and that was also a 10-year deferred probation. Is that correct?
Yes, ma'am.
Each of these motions allege that you have violated your probation Count one in each motion alleges that you committed the new offense of theft of property on September 24th, 2024 in Fort Bend County. And is that true or not true?
True.
Count two.
Just when one defendant receives a second chance, another faces a much harsher reality. After admitting to serious probation violations tied to an aggravated robbery case, this defendant's fate is about to be sealed. What Judge Raquel West says next leaves no room for hope, excuses, or appeals.
In each case alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true? Count three alleges that you provided a urine sample October 19th of 2021 that tested positive for marijuana in Harris County. Is that true or not true? Count four alleges that you provided a urine sample November 30th of 2021 that tested positive for marijuana. Is that true or not true?
True.
Count five alleges that you provided a urine sample that tested positive for marijuana March 14th of 2022. And is that true or not true?
Judge, if it's all right with the board, we can stop there since we have an agreement.
I just don't understand why this went on for so
It was a Harris County supervision, and it looks like they didn't send anything over until after she had fled on the
Yeah, she was
cases.
actually out of jail when they filed the motion. They filed the motion until November.
Okay. You enter your pleas of true to counts 1 through 5 freely and voluntarily.
Yes, sir.
And did you plead true to those because they're actually true?
Yes, sir.
In each of those cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, sir.
Do you fully understand them?
Yes, sir.
And do you understand if I follow the agreements that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, sir.
State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Ms. Henry is not competent?
No, Your Honor.
All right, Ms. Henry, in each of your cases, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence in each case to find you guilty. And at this time, in cause number 14-19-449, find you guilty of aggravated robbery. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding of a deadly weapon in that case. And then in cause number 14-19-624, also find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding of a deadly weapon in that case also. These cases will run concurrently, which means together at the same time. I've handed you the trial court certification in each of those cases that shows that these were agreements that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, ma'am. You can go back with the bailiff.
Thank you, Your Honor.
Good morning. Are you Edward Godfrey III? And will your client waive the formal reading of the indictment?
Well, Your Honor.
Mr. Godfrey, in cause number 26, DCCR 0383, you're charged with the 3rd-degree felony offense of assault, family violence, by impeding breath or circulation from February 6th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please.
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them?
No.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for an 8-year deferred probation. Is that right?
Yes, Judge.
Is that right?
I wrote it at 8, but
That was the original, but it was a 6. I
I,
haven't
but
got
I,
to a
but
6
I,
here.
but I had it 6. I
It
just
should be 6.
read it wrong. It's 6.
Okay, so, with y'all's permission, can I change this,
Yeah.
punishment recommendation? So it looks like the agreement is for a 6-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
No.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Godfrey is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back for sentencing at a later date.
Today's courtroom session delivered powerful lessons about accountability, second chances, and the consequences of ignoring court orders. While some defendants were given opportunities to rebuild their lives, others walked away with prison sentences and felony convictions. Judge Raquel West made one thing absolutely clear: a second chance is a gift, but wasting it can cost everything. If you enjoy real courtroom stories and legal drama, make sure to subscribe and turn on notifications so you never miss our next case.